2015, and bring us to LB206 and Senator McDonald. Good morning and welcome to the Judiciary Committee.
Good morning. Good morning, Senator Lathrop and members of the committee. My name is Mike McDonald, M-I-K-E-M-C-D-O-N-N-E-L-L. I represent Legislative District 5, South Omaha. I come before you today to present LB206, which seeks to update and modernize Nebraska's arson statutes. I have introduced this legislation on behalf of Attorney General Peterson's office in an effort to help facilitate and implement these changes. In a broad sense, LB206 includes updating definitional terms used in Nebraska's existing arson statutes, as well as additional provisions that will make Nebraska arson statutes applicable in a greater number of intentionally set incendiary fire scenarios. The legislation also includes a penalty adjustment that was overlooked in previous sentencing reforms and allows for a sentencing enhancement under certain circumstances. And I apologize, I've got my testimony I was going to hand out for you guys. More specifically, LB206 eliminates the term and definition for building in section 28-501 and replaces it with the term structure, in order to broaden the instances where Nebraska's arson statutes are applicable. This broader definition is necessitated by the fact that human lives are being risked by fires set in locations that do not fit within the current existing definition of building. This change is also made in sections 28-520, first degree criminal trespassing, and 28-524 graffiti, as both sections are just as reliant on these terms. And LB206 adds burns and causes to be burned to the list of acts prohibited in various sections in order to harmonize each with the prohibited acts listed in section 28-504. The bill also adds maintains a fire to the list of acts prohibited by all of Nebraska's existing arson statutes in order to hold persons criminally accountable for escalating a fire even though they did not set the fire. LB206 adds a definition for human skeletal remains and makes burning, setting fire to, or maintaining a fire to any structure punishable as arson in the first degree if the perpetrator did so knowing that a person might be inside and regardless of whether they believe that person was alive or dead at the time. The bill also makes burning, setting fire to, or maintaining a fire to any structure, person, human skeletal remains, or item of personal property punishable as arson in the first degree if the perpetrator did so in order to conceal the commission of a crime. Last, LB206 adds a definition for public safety official, also the applicable sentence on all arson offenses to be enhanced one penalty classification higher if the offense committed causes a public safety official to sustain serious bodily injury. It is reasonably foreseeable that a firefighter or first responder could be injured in the line of duty when someone deliberately makes the choice to set something ablaze or blow something up. The bill also makes arson in the second degree a Class 2A felony as opposed to a Class 3 felony due to an oversight when LB 605 was passed in 2015. During my time as a firefighter, I witnessed terrible accidents and horrible crimes as a result of fire. LB 206 further addresses intentional acts of arson by eliminating gaps and gray areas that currently exist within our laws. Assistant Attorney General Mike Guinan will be testifying on behalf of the Attorney General's office to provide insight regarding the need for this legislation. And Terry Zewiebel, Fire Marshal with the North Fork Fire Division, is also here to add perspective based on his years of arson experience. I'm here to answer your questions, and I will also be here for closing.
Senator DeBoer.
So maintaining a fire, does that require an action? Can you, if I just stand by and watch something burn but don't put it out, Is that maintaining a fire?
I believe it's actually a cause of action, but I'll let the people behind me answer that question. Mark.
Okay, sorry.
I don't see any other questions. You will be here to close?
I will be here to
Since you have
close.
the next bill? Good.
Yep.
All right. We'll take proponent testimony.
Thank you.
then. Welcome.
Good morning, Chairman Lathrop and members of the Judiciary Committee. My name is Terry Zweibel, Terryzwiebel. I'm the president of the Nebraska chapter of the International Association of Arson Investigators. I appear before you today on behalf of the fire investigators that are members of our chapter and the chapters of the International Association in support of LB206. The Nebraska chapter of the International Association of Arson Investigators support this bill for the following reasons. This bill will make the needed changes to how the crime of arson is prosecuted in regards to using a fire to conceal another crime. I believe another witness will be able to speak to several criminal cases that have been prosecuted in this state and not been able to get the higher crime about. These case facts are what has influenced our association to speak in support of this bill. Defining and adding the description of human skeletal remains to this statute gives the ability to charge the first-degree arson when the situation arises. Additionally, this bill will return second-degree arson from a third-degree felony to a 2A felony. The added definition of a public safety official as a person in the official capacity at a fire scene, including firefighters, both career and volunteer, law enforcement personnel, EMS providers, and fire investigators, thus allowing for persons or persons who start a fire on a public safety official is injured to increase this charge one step. This bill will help to protect public safety officials who are charged with the very dangerous job that is made even more dangerous when a person who is trying to destroy evidence in their crime by fire, usually by a very aggressive means that makes the job we do even more dangerous. With that, on behalf of the Nebraska chapter of the International Association of Arson Investigators, I would like to ask this committee to advance LB206 to general file and would like to thank Senator McDonald for introducing LB206. I would like to thank the Judiciary Committee for your time in this matter and would be happy to answer any questions I'm capable of answering for you at this time.
Senator DeBoer.
Yes, ma'am.
I'm going to ask you the same question I asked Senator McDonald. What constitutes maintaining a fire, or what would constitute maintaining a fire in terms of, is there a fact pattern that you guys investigate that would sort of fit in that category generally?
If they would allow it to continue to burn without reporting it or attempting to extinguish the fire, would be my answer to that question. I don't know that's the legal term for it, but if you don't try and get somebody out there to help put that fire out, then to me you're maintaining that fire and allowing it to burn.
Is that something that you have seen happen a lot? You find evidence of that a lot?
Personally, no, but there have been incidents in the state where an abandoned building has been allowed to burn with possible personal property in it. I'm aware of a few cases in that case where that would happen.
Okay, thank you.
I have a question from Senator Pansy Brooks, who's in quarantine. Why the change of verbiage from starting a fire to burn or causes to be burned? What has happened and how does the suggested language help cover more illegal acts?
Well, every fire has a start, obviously, but it clarifies the language that they are making it burn, where there have been places where they have attempted to, but it didn't actually burn. So that would help to clarify that section.
Page 2, line 28 and 31. Let's see what this, page
228 person.
Yeah, okay. Let me ask another question. Tell me, why are we changing from building to structure? What's a structure that wouldn't otherwise fall into the category of building?
A building would, in the original definition, if I remember correctly, is a habitable building, where a structure is anything that has four walls, a roof, which could include like a barn or something of that nature.
So you don't think previously or currently that a barn would be covered by the term building?
Could or could not, depends on how it's state of repair, disrepair, however you want to put that.
So would we now consider is a shed in the backyard that I put my mower in and my rake and my snow blower, is that a building right now?
Yes, it would be a building right now, under this current statute.
Okay. All right, any other questions? I don't see any other questions. I have to check my phone to make sure Senator Pansy Brooks doesn't have any, which is fine. So that's the reason for the delay. Thank you for being here today. I appreciate it. Any other proponent testimony? Welcome.
Good morning. Good morning, Chairman Lathrop and members of the Judiciary Committee. My name is Mike Guinan, M-I-K-E, Guinan, G-U-I-N-A-N, and I'm a criminal prosecutor with the Nebraska Attorney General's Office. I appear before you today on behalf of Attorney General Doug Peterson and the Nebraska Attorney General's Office, along with the Nebraska County Attorney Associations, in support of LB206. On behalf of the Attorney General's Office, we proposed LB206 in large part as a result of our experience in a murder trial 2 years ago in Cumming County. A very basic version of those events were two men went to the victim's country home late one evening. There was an altercation. Knives were produced and used during the altercation. One of the two men stabbed the victim in the back and the neck 15 times, killing him. The next afternoon, that same man went to the victim's house and burned it down. In addition to murder, we did charge first-degree arson, as our deceased victim was still present inside the house at the time of fire. At the end of the state's case, defense requested the court dismiss the arson count as there was no quote-unquote person present in the house at the time the fire was started. Despite our arguments to the contrary and finding no assistance in Nebraska statutes, Nebraska case law, nor clear guidance in case law from outside the state, the court granted a defense request and instead allowed the state to proceed forward on a second-degree arson. Ultimately, that man was convicted of second-degree arson in addition to a murder charge. The second-degree arson took the charge from a Class 2 felony, which would have been first-degree arson, down to a Class 3 felony as it reads now, which is 0 to 4 years. This was the genesis of LB206, which proposes several changes to the present arson statutes, primarily 28501 to 505. Senator McDonald covered most of these. I'd just like to highlight a few of them. First and foremost, among these changes, we propose that second-degree arson be amended to a Class 2A felony, which is 0 to 20 years. This would be a correction from back at LB 605 back in 2015 to raise that penalty up along with the other ones that were raised from a Class 3 to a 2A. This one was apparently overlooked. We also, as Senator McDonald mentioned, we have changes that include increased penalties faced by the arsonist if a public safety official is injured during the course of fighting that fire. From a prosecution standpoint, we have proposed this statutory section with the belief that it is fitting that the applicable penalties the arson faces should increase when the fire he or she intentionally sets not only destroys property, but maims a public safety official. With that, on behalf of the Nebraska Attorney General's Office and Nebraska County Attorney Association, I would ask this committee to advance LB206 to general file. In so doing, would like to also thank Senator McDonald for introducing the bill, and happy to answer any questions on this.
Senator DeBoer.
I have a couple of just very technical questions for you about, maybe it's language, maybe we need to clean up the language. Under the definition of structure on page 2, line 12 through 15, it includes a tent, a portable building, a vehicle, a vessel, a watercraft, or aircraft. The vessel, to me, I mean, I don't know if we have a definition of vessel somewhere, but vessel, I think, might be overbroad for what we're trying to get at here, because a vessel, I mean, technically I could call this a vessel. So
Good.
that probably is something that we need to work out. Is there some reason why you included vessel in there? Do you know?
Senator, I think, if I recall correctly, it's been a while since we did this, but I think we borrowed from a statute out of Florida, and maybe the vessel piece, the watercraft would probably cover, the vessel piece might have been something that might have been more specific to a ocean state.
Yeah, we might need to look at that definition and just make sure all of those things are really what we want. On page 3, lines 14 through 18, if they intentionally set fire to an item of personal property in order to conceal the commission of a criminal offense, if I put a piece of paper into my fireplace in order to conceal some money laundering or something, am I now also able to be convicted of arson? I mean, that's the problem, is it seems like a piece of personal property could be pretty expansive, and if I light fire to a piece of personal property, just about anything could do that, and any time that I would be hiding a crime by doing it, that would mean I was then able to be convicted of arson?
Right, so, yes. So the way that the statute is written is to contemplate, in this particular case, under your scenario, to contemplate destroying evidence of a crime. And in that case, if you burn a piece of paper, yes, true, you could be charged that way. That's also up to prosecutorial discretion. So that's a possibility.
We probably need to clean up that language. The last thing I have to ask is the cause to, let me get the language right, the keep it burning, what is the, maintain a fire, there we go, maintain a fire. Does this create a duty now in random passersby? I walk by a building, I see it's on fire, I think, probably somebody's putting it out, but I don't do anything? Have I now maintained the fire?
No, you have not. There is no duty under the criminal laws to stop or to mitigate a crime. What this gets at is, if you remember the prison riots, the issue with the statute right now, and the issue that we were having at that time, is the language talks now about setting or initiating a fire. What was going on with the prison riots were they initiated these fires. It was difficult to determine who was doing what. It was obviously a very difficult case or cases, but some of those fires were initiated, then people will come along with accelerants and spray like baby oil and those kind of things onto it, which would, increase the fire, expand the fire, or continue the fire. And that would be the proactive step that needs to be taken in order to be convicted of that crime.
So it can't just be passively standing by and not accelerating the fire?
Correct.
So we might also have to have a definition of maintain the fire in here as well, I would think, just to make sure that we don't over broadly get at all of those things.
Sure, that makes sense.
Okay, thank you.
Senator McKinney.
Thank you.
Yes.
Thank you for your testimony. I have a couple questions. I was curious, don't public safety officials such as police, security guards, and firefighters assume the risk of duty? And I'm just curious, why should there be punishment implemented if they get injured in a case of arson?
Yeah, it's a good question. So if you, I guess the logic behind it, if you think about it, so in a normal fire, the first thing that happens is people leave and run. And of course, our public safety officials, their job is to then proceed to that danger. The idea here is to, if the fire is not an accident or a natural cause and so on, if it is an incendiary, an arson type fire, we believe that the arsonist ought to be held at a higher level or be able to be punished at a greater level because the public service official received serious bodily injury. So not just bodily injury, so not sprung my ankle while I was out on the scene, but this is somebody who has essentially maimed, that they ought to face increased penalties.
Okay, but why is there a difference?
A difference versus,
Regular arson.
okay, well, this would be a regular arson, so an arson type scenario.
I'm talking about versus natural fire. That's what I mean.
Oh, a natural fire. Right. So, understandably, when this is a dangerous line of work, understandably, and firefighters face a myriad of dangers in that line of work. Heat exhaustion and so on. I mean, and on to the point where it can be serious bodily injuries, maiming. Why the difference? Because of that. Because that arson would not have, or that fire would not have been set but for the arsonist's action. So if that is the root of this and somebody has started this fire, we feel that they should face an increased penalty if somebody that's responding to that scene has basically a life-altering type injury.
Okay. Another question. The wording attempts to modernize arson provisions. What other states are following this trend?
The attempts to modernize?
Yes.
So we borrowed from, if I remember correctly, borrowed some language from Kansas and Iowa, Florida. The statutes that we looked at are, I have a printout, but we basically went through and pulled, at the time, we had a law clerk, and pulled all the state statutes from all 50 states. So there's we kind of sifted through that to find language that might help modernize ours. I don't have a specific, I don't know which specific states were modernizing or modernized in a recent time period.
Okay, one last question.
Sure.
What if, okay, you have a teenager, 17 years old, accidentally start a fire? Is that considered arson? Is that considered an accident? And how would that be treated under this bill?
Right, so the arson statutes require intentionally setting a fire. So an accident, depending what the facts are, an accident would be, may not be chargeable. And so...
When you say may not, what does that mean?
Well, I guess it would depend on the...
Sometimes, we have 17-year-olds that accidentally shoot somebody and still get charged as adults.
Mm-hmm.
So I'm just curious if that, under this bill, could that potentially happen?
It depends how you use the word accident. If an intentional act that starts a fire or causes a fire certainly could be charged. If it is like out in the world we say accident, and it truly is that they tripped over something and knocked a candle over, That would be an accident. That wouldn't be an intentionally set fire.
So what if they're being, you know, as teenagers are, kind of careless and a little reckless and, you know, I think everybody in here probably played with fire before. They're playing with fire and something bad happens. You know, firefighter goes in and gets injured. Is there potential for that individual to be charged as an adult?
Yes, under the the amendments and under the statutes as they are right now, yes.
Okay, thank you.
Okay. I don't see any other questions. Thanks for being here today, Mr. Guinan.
Thank you.
Anyone else here as a proponent? Seeing none. Anyone here as an opponent of LB 206?
Good morning, members of the committee. My name is Spike Eicholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association opposed to LB 206. As I said before on an earlier bill, the ACLU opposes this bill because it does increase, really across the board, a whole series of felony offenses, including, if Senator Pansy Brooks is watching, it does add to the list of mandatory minimums on page 3, lines 19 through 21. And increases that penalty to a 1D felony, which is a mandatory minimum. As far as the defense attorneys, we have some additional concerns with respect to the bill, and some of the committee members have asked about that. If you look at the definition of structure that replaces the definition of building that's in the current arson statutes, that's problematic. If you look up page 2, lines 12 through 15, structure means any building, any enclosed area, any real property, and I don't know what appurtenances means, actually, to be honest, to which the building or enclosed area is attached. So that would include a field. The intent requirement to start the fire needs to be met, and that you can easily imagine a scenario where somebody is intentionally burning brush, the fire gets out of control, it catches in the field, it even maybe hits a building. While the volunteer fire department is responding, there's an accident, and when somebody suffers a serious bodily injury because of that accident, that's a 1D felony. These are dangerous situations. I don't mean to minimize that, but the level of penalty ought to have some sort of rational connection to the egregiousness of the offender's conduct. And particularly when you talk about start a fire, maintain a fire, those sort of ongoing violations that you can make with respect to a fire, that's kind of problematic. I think what Senator DeBoer mentioned on page 3, lines 14 through 18 is a legitimate concern. If you intentionally set fire to an item of personal property in order to conceal the commission of a criminal offense, that's a very good example right there. Burning a stolen checkbook that you've been charged with or suspected of committing forgery. When you asked that question, Senator DeBoer, I was reminded that there's other crimes that, of course, these acts involve. And in that example that you gave, there would be a number of crimes of tampering with evidence, which was increased the penalties for that last year or the year before by Senator Wayne, which would be another separate quaternary felony. So for the reasons that I tried to state here in the time I had, this does increase penalties, and it is problematic for us for a variety of reasons, as well as the definitional changes with respect to the crimes of arson. And we urge the committee not to advance the bill.
Okay, any questions for Mr. Eicholt? I see none. Thanks for being here today. Any other opposition testimony? Anyone here to speak in the neutral capacity? Seeing none, Senator McDonald, you may close. We do have 2 position letters, both proponents, and we also have a letter of support, rather written testimony this morning as a proponent from Jerry Stillmock, who is with the Nebraska State Volunteer Association and the Nebraska First Fire Chief Association. Senator McDonald, close.
Thank you. If there's ways to improve this bill, then please reach out to me. But let's talk about public safety officer a little bit in the definition and Senator McKinney's questions. So you have a firefighter, and the idea they took an oath, check life and property. And part of the idea of firefighting, it will always be a dangerous job. But then as fire management, part of your job, and I believe as the labor movement, is to take a dangerous job and try to make that safer. So you look at a public safety officer and you define that, and you put in there as firefighter, and you look at the ways you can take and make a dangerous job safer with training, technology, with personnel, and also with the idea of taking arson and taking it seriously and recognizing it is a crime that can take life. So you have a firefighter that if we make that change on page 5 and we say, okay, it's going to be a class 2, go from a class 2 misdemeanor to a class 1 misdemeanor based on if it's $500 or less, but if a firefighter gets injured, seriously injured, then at that point, we are doing our job, I believe, as lawmakers, working with fire management to try to make that dangerous job and make it safer. Because we are looking at that person possibly committing their next crime. And if we can stop that, deter that, and put that person on a different path, then it is going to possibly save a citizen or firefighter's life in the future. So that part of the bill, and working with our subject matter experts in the Attorney General's office and the fire investigators and knowing what they're going through and their stories, our job, I believe, is to try to improve things. And on this law, again, with your input, let's make those improvements, and let's try to make sure that we're standing up for those firefighters out there that are doing their job, took their oath, and it is a dangerous job, but also let's try to make that dangerous job safer.
Okay. I appreciate your close. I don't see any follow-up questions, so that will close our hearing on LB 206 and bring us to